Hello, everybody.
All right, we're going to call next matter of the State of Michigan versus Darrell Wayne Curtis Jr. This is file number 24-5353FC.
Sierra Coke on behalf of the people.
Thank you, Honorable Ravi Gordon-Murthy, on behalf of Mr. Curtis.
Thank you.
And
In the Roscommon County Jail, sir, you Darrell Wayne Curtis Jr.?
Yes, sir.
Mr. Gurmurthy, did you have something you needed to cover?
I did, Judge, and Mr. Shiloh Engels should be in the courtroom as well. I just wanted to make sure that he was present in the courtroom for this hearing.
Or if you could stand up so that the attorney and Mr. Curtis can hear that you're here.
Your Honor, yes, I'm observing today these proceedings.
And your name?
Tyler Engel, P75720.
So are you somehow involved with this case?
I've been asked to basically offer a consultation to the defendant.
Well, so you have not filed an appearance.
That's correct.
And you, at least at this point, don't know whether or not you're going to file an appearance.
That's correct.
So you're, of course, welcome, like anyone is, to view the proceedings today, but for obvious reasons, I'm not going to hear from you. Mr. Curtis hasn't retained you. If he retains you, I'll certainly hear from you, but not until, and I think that's probably fairly obvious to you, but you're welcome to observe. Mr. Curtis, have you had enough time to talk with your attorney, Mr. Gurmurthy, about this case?
I have not, sir. I need to talk to him more about the case.
Why have you not talked to him about the case prior to today's hearing?
I have contacted him. He's contacted me, and then I got put in here 2 weeks ago, and this case is being dismissed tomorrow. I just haven't had time to respond back with him since then.
Mr. Curtis, this case was bound over to my courtroom, to the circuit courtroom back in November of 2024. So coming up on 4 months ago. You've only been in the Roscommon County Jail, you said, a couple of weeks, right?
Yes, sir. I was in the Crawford County Jail prior to that on bond violation for a picture.
I'm aware of that. I'm the one who signed the order remanding you to jail for those bond violations. During all the time you were in the Crawford County Jail, you're telling me you didn't have enough time to talk to your attorney?
I did not talk to him, except for on the phone there.
If I can clarify, the last 2 weeks when he was in the Roscommon jail is where we haven't had contact. But prior to that, Mr. Curtis and I did have contact. Mr. Curtis has provided me with the necessary witnesses and statements and things and photographs that I've requested. So there was contact prior to that. And then I've maintained contact with his mother, who has provided necessary information for me as well. And then as of Friday so 3 days ago, excuse me, Mr. Curtis's mother indicated to me that they were going to seek a second opinion from Mr. Engels. And I simply wanted to have Mr. Engels identify, so Mr. Curtis knew that Mr. Engels did come up here and intends to meet with him after the court hearing today to go over the second opinion that Mr. Curtis intends to have.
Well, let me ask you this way then, Mr. Gurmurthy, because if it's one that your client is asking for more time to meet with an alternative attorney, I have to look at that and decide whether or not that provides good cause to adjourn the jury trial that's currently set. Is that what you're telling me? Is that you think it provides good cause to adjourn the trial that's set?
No, I don't think. In speaking with Mr. Engels, I think he would be ready to go to trial as well, which is set at the end of April and the first day of May. So I don't think we're asking for an adjournment for the trial. And I would be ready for the trial as well, that is already set. So what I'm simply letting the court know is Mr. Curtis and I are ready. We would be ready between now and April, because my understanding is he does get out tomorrow. So we're not asking for an adjournment. I believe there'll be plenty of time. And I've discussed this case at length with Mr. Engels as well. So based on that discussions, I think Mr. Engels, if he were to substitute in, would also be ready.
And so you're telling me, in other words, that the plea cutoff, which was set for today, is going to be rejected and there is going to need to be a trial in this case. Is that more accurately what you're telling me?
That is correct, unless something changes between the conversation Mr. Curtis and Mr. Engels have, which certainly they haven't had.
Mr. Curtis, is that accurate? You wish to deny any plea agreements and have a jury determine the issues in this case?
Is it still the same plea? No.
Ms. Cope, for the record, could you tell me what the plea offer was?
The offer was possession with intent to deliver. The offer was made on October 8th So just shy of 5 months or around 5 months ago, we are prepared for trial.
So can you tell me then, the offer being that, what would you be dismissing in terms of the plea offer?
The carrying concealed weapon, the habitual fourth notice, the DWLS and the DWLS second enhancement. And I think there's a possession charge as well at the end of it, all of those.
All right. So Mr. Curtis, was that the plea offer that you were aware of?
There was no possession. It was a delivery. I was charged with delivery, weapons charge, and driving unsuspended and probation violation. And I thought it was offered for me to drop everything to a delivery. I didn't know it was a possession. What would be the, what would my guidelines pertain to for that possession with intent? I don't know.
So guidelines, Mr. Curtis, as you've heard so far today, but let me clarify, aren't part of the inquiry here. They might be important to you, but they're not part of the inquiry for this reason. Guidelines are scored by the court, not by the attorneys. So the attorneys are the ones who are negotiating this potential plea offer. But the attorneys aren't the ones who ultimately score the guidelines. I am. That's why guidelines ranges in about 99% of the cases have nothing to do with the plea. The only exception to that is the attorneys at some points would approach me and ask me to agree with them or disagree on a guidelines range. That's called a sentencing agreement. The attorneys haven't approached me about that, and I'm not willing to engage in a sentencing agreement because they haven't provided me that information. So the plea agreement would be as if you plead guilty to the possession with intent to deliver methamphetamine. The prosecutor would dismiss the carrying concealed weapon, the driving while license suspended, and the habitual offender fourth offense notice. Do you now understand that plea agreement?
I do understand now, sir.
And the plea scope, was there something additional?
Your Honor, on December 10th, we did do an amended felony information that included the labs for possession of fentanyl. So that was the fourth count. And I think Mr. Curtis is misunderstanding something. I just want to clear it up because I heard it. I don't know if the court heard it. The offer was possession with intent to deliver, which is under the same statute as delivery. The offer was not straight possession. Your Honor said it correctly. Mr. Curtis did not.
And that is what I've advised Mr. Curtis as well, that it's a 20-year B grid, B for Bravo, B grid felony. It's not a D grid possession, 10-year felony. That it is, and then we went over this at the last court hearing as well, Judge. I think the court apprised Mr. Curtis of the tail end, which would be a life offense, and all the other charges. And Mr. Curtis rejected that, and as of now, my understanding is he's still rejecting this offer. So I want to make sure that he's clear that it's not a possession of methamphetamine. It is a possession with intent to deliver methamphetamine, a 20-year felony.
Are you clear about that plea offer, Mr. Curtis?
Yes, sir, I am.
And did you wish to take advantage of the plea offer or reject it?
I wish to reject it, sir.
You understand if you're convicted at trial as a habitual offender fourth offense notice, the maximum penalty is life.
Yes, sir.
And you wish to reject the potential plea offer, understanding fully the maximum penalties that are instigated if you're convicted at trial.
Yes, sir.
So the court will keep the trial on. However, as the attorney that was here in the courtroom heard, and Mr. Gurmurthy, I don't think you were in my hearing room yet, I have a different trial which has a predated case number on the same date. This trial will therefore not take place on April 30th and May 1st, but I'm going to set it at my next available date, which will be very soon. The April 30th and May 1st date is set for a different case, which is set on the same days. This case will have a standalone trial date. It will be set at my next available date, but this one will be the case that will go, meaning it will not get bumped or moved in any other case because Mr. Curtis is and will remain, at least until I order otherwise, lodged in Crawford County. So I'm going to set it as soon as I possibly can. Ms. Koch, is there any specific time period that the people need, or are you ready to proceed as soon as I can set it?
We're ready to proceed.
And Mr. Gurmurthy, same question for you. You said you're ready on April 30th. Does that mean obviously you're going to be ready to proceed to trial as soon as thereafter I can set any date?
Correct. I have all the requirements of the evidence that Mr. Curtis for his defense wanted to provide me. I have those. And if anything else comes along the way, we'll just supplement those, but we're ready.
All right. Mr. Curtis, we'll see you in your morning of trial. If to the extent I issue an order later that affects your bond, you need to be aware that the requirement is you're here and your attorney's here in the courtroom no later than 8:30 on the morning of trial. Have you yet made arrangements with Mr. Gurmurthy for proper building for trial?
I was to the understanding that I was still on bond for that case, and this case is being dismissed tomorrow.
You have not had a bond. I have revoked your bond. I remanded you to jail, and so there is no bond that was in place. Am I misunderstanding something, Mr. Gurmurthy?
At the last hearing, we had a new bond that was set for Mr. Curtis. He posted that bond. And then
I didn't recall that, and so I'm glad I'm having the attorneys refresh my memory. Mr. Curtis did post a bond after I set a new bond. Ms. Coker, are you aware of that?
I don't generally know when they post them, but Your Honor did set a bond for cash or surety at $20,000 on 12125.
To the extent, Mr. Curtis, that you've posted a bond, and I don't see that information, but that's fine. If you posted a bond after I said it, that bond will continue unless and until I'm given information to suggest that it shouldn't continue. I was apprised of my memory, and apparently I set a bond, and apparently you have posted it. Again, unless I change that order, you'll be either remanded if I didn't issue the bond, or if you posted that new bond, you'll be subject to all the conditions in that new bond. Ms. Medler, do you have a copy? I just gave you the court file back. You have a copy of that updated bond. You have a copy of your
Still show
system.
that there is an open bond, but then no, he did post through Craig's 21.
Okay, so you're still on that bond then, Mr. Curtis, assuming that everything's dismissed from Roscommon County, you're not held anywhere else in the state. So we'll see you at your trial date. You'll get a notice in the mail for it. Let me have your address again so I make sure and send your notice to appear at the right address.
It is 751 Grading, Michigan.
Thank you. Is that what you had?
Yes.
All right, we'll get the notice for the new trial date to your address, Mr. Curtis, and to each of the attorneys. Do each of you still believe that the two-day trial is warranted and necessary? Still.
I think that I'm going to be done in one day, but I think if defense brings in several witnesses, we're going to need the second day. I don't know that we're going to know that until the trial.
Mr. Murphy, do you think having a two-day trial is a safer bet if you're going to call witnesses?
it is, Judge. So far, we've identified about 3 witnesses that we intend to call. So given those 3 witnesses, albeit they might be short, I think we might be better off going into a day 2 so that we have ample time to present the defense's case. I also wanted to say for the record, Judge, at the last hearing, we did indicate that Mr. Curtis could raise a defense of a lesser included of possession of methamphetamine. And I think the court indicated that we did not have to file a separate notice or a motion for the lesser included because we did apprise the prosecution and the court of that.
Well, because the prosecutor stipulated. That's correct.
Yes.
Right, let's go.
Yes.
Right. You don't need a motion for it.
Okay.
Right, stipulation of the prosecutor. So I'll expect jury instructions no later than 14 days before trial, and we'll get this matter set. Thank you, Mr. Curtis.
Thank you. Have a good day.
I also had Holly Harris that I'm going to bring in. My understanding is Holly Harris was a person who suggested some form of treatment or counseling. I received letters that I'm sure the attorneys had and we'll cover that as well. We're on the record in the matter of People versus Laura Ann Kenny. This is file 24-5355FH.
Sierra Coke on behalf of the people.
And thank you, Honorable Governor, on behalf of Ms. Kinney.
Thank you. And ma'am, are you Laura Ann Kenny?
Yes, I am, sir.
Ms. Kenny, we're here for a status conference today. Have you had enough time to talk with your attorney about what you want to do today?
Yes, I did.
Mr. Gurmurthy, did you have a suggested course of how the court should proceed today?
Yes, Your Honor. Your Honor, excuse me, Ms. Koch's office indicated and tendered us a plea in this matter to count 1, attempt false report of a felony. So that would be an added count. The habitual second offender notice would be dismissed. And Ms. Kinney would be pleading no contest to that attempt charge due to lack of memory. And I did provide the court with a copy of the police report to review for taking of a no contest plea.
Is that accurate, Ms. Koch, that the plea is for an attempt dismissal of the charged offense in the habitual second?
Yes.
Do the people have an opposition to a no contest plea?
No,
Do you think the lack of memory would be an appropriate basis?
it is.
The court would note that in advance of the hearing, I was provided a police report, which I reviewed in full. The police report does not convince the court that there's proof to accept the plea, and so I will not accept it on a no contest theory. The court doesn't have any issue with no contest pleas, but I've explained this several times to the attorneys, but perhaps I need to explain it again. When I have a case, and this is a significant case, it's an allegation of false report of rape of criminal sexual conduct. And when I have that and I have clear indicia of guilt, I will and have no issue accepting a no contest plea if I find it to be appropriately established. But where in this case, and in other cases that have been recently submitted to me, I have clear indications from the defendant in a police report that they're denying any wrongdoing, I'm not going to make findings of guilt or make a determination whether or not the denial is believable or not. That's a jury's function, not a court's function. I will not accept pleas where defendants tell me they're not guilty, and I will not accept no contest pleas where the evidence clearly doesn't preponderate that there's any type of criminal activity. In this case, Ms. Kinney, according to the police report, the summary of the facts is that she reported that she was violently raped by 2 individuals. She reported then that that happened and repeatedly reported that to police, that she was violently raped. Other information suggests that the other individuals were interviewed and denied violently raping her or raping her in any way. And they consented to, at least one of the individuals consented to a DNA test. And there was some other clothing brought up and tested. No other indication of guilt is indicated anywhere in the police report. And I won't suppose that that's the case under a theory of a no contest plea. I simply don't find the interest of justice to be served by that. So, Mr. Gurmurthy, I will not accept a no contest plea for those reasons, not because of the no contest plea itself, but because of the lack of facts that convinced me of guilt from the police report. Did you have something else I should consider other than the police report you've offered so far?
No, Judge.
Mr. Oak, is there something else I should consider outside of the police report that's been shown so far?
No, we'll be prepared for trial then.
Do you believe that the police report establishes guilt, Ms. Koch?
Well, I charged it based on what I read in the police report, which was her statements that were not corroborated in any way by any of the evidence. And frankly, all of the evidence corroborated the opposite.
Is there
But
more evidence other than the police report? Did you talk with, for example, Detective Sergeant Colabbo?
well, I talked to the officers. We've talked to the victim, or the victim that she said raped her.
So more information is known to your office when you charge the offense than is provided in the police report.
Yeah, I suspect, yes.
And so your belief is that there's guilt, but I'm asking a different question. I know that it's difficult maybe for you to separate them from the police report where a defendant says that she was violently raped and where no statements contrary to that are there. How would I find guilt?
And I think that when I looked at the police report, there's a recorded conversation that it states it in there, but it doesn't state what it said. So I think I probably had significant more information when I charged it. So I understand we can be prepared for trial and we will go forward that way.
Mr. Gurmurthy, how from the police report you submitted to me would the court find guilt? What am I missing?
The statements made by Ms. Kinney I would echo Ms. Koch's sentiments that they were not then corroborated with the interviews with the other individuals, plus the lack of memory that Ms. Kinney had at the time when she made those statements.
Well, look, counsel, lack of corroboration, as the attorneys well know, is not it's not an element. If her statements are that she was raped and a jury were to believe her, that's enough for a conviction.
And on supplement too, she specifically says Laura made statements that she did not think the men raped her. Laura made statements that she was having a flashback from a previous sexual assault from another person. Laura made statements about wanting to make sure the case was dropped against the 2 men.
There's a supplement because unless I missed it, I didn't get a supplement. I got a single police report, but if I would have read that information, it may have changed my analysis. Was I provided a supplement?
I did not provide it, so I do not know what Mr. Gurmurthy did, and I apologize. I was out of the state on training last week, so I didn't know they were doing this as a no contest plea until about 20 minutes ago.
Mr. Gurmurthy, did you provide a supplement?
I provided about 14 pages, and that was part of the supplement. So I don't know if that came through or not, but I can certainly re-provide it.
The court's going to adjourn. Counsel, you need to be better prepared if you're going to seek a no contest plea, and you should clearly understand that for this case and every case into the conceivable future for me, if there isn't clear evidence of guilt within information you provide to me, I will not accept the plea, ever. And from what I've read, there is not clear indication of guilt, and I won't accept a plea on that basis. If I've missed something, then I want you to tell me where I've missed it. But I haven't read the things that Ms. Koch just indicated. If those things were provided in a written police report, it might change my analysis. But you're going to have to do a better job of providing me the information upon which you're seeking a plea to be entered. And frankly, you're going to have to do it before 20 minutes before a hearing date. Do you have any questions about the court's statements, Mr. Murphy?
No.
Ms. Kenny, I'm going to adjourn. I find good cause to do so because apparently there's information out there that may assist me in making a finding in this case. But we're not going to get there yet because in my view, at least, I have not been provided it yet. So I'm going to set a new hearing next month. You need to stay in contact with Mr. Murphy, and then you can decide ultimately how you want to proceed. Do you have any questions, Ms. Kenny?
No, Your Honor.
Ms. Koch, anything further in light of what's happened so far?
No, thank you.
We'll be in recess and we'll see everybody in about a month for a new status conference.
Be safe, be well, sleep sweet, and much love.